Okay, it's about 8:30 p.m. Central Standard Time, and welcome to week 6. Finally got to use 2 hands, 5 and 1. That's it. We don't go to 7, so this is the end of it. And if you're looking for a week 7, won't be with me. So you can hopefully have 2 weeks of rest um, till November the 4th. I'm sorry, November 4th. That's too long. October the 4th. Yeah, I was setting myself up for what I said last night to my class. October the 4th, and may the 4th be with you. So it will be coming on. So get ready for that break. I'm sure that you guys can appreciate it. I can certainly appreciate it this term. I've had over 100 students. So my wife says, your eyes look tired. Don't go in there with your face looking like that. You're going to scare your students. So I need Juan to kill his camera. Nice, Juan, very nice. He can, but you need to kill that camera because it's going to mess with the bandwidth. You know how to do that? Hit that camera thing and it will turn off the um, there you go. Okay. Juan Baez. You know, when I first saw your name, Juan, I thought about a singer years ago, back in the 60s. Her name was JB also, J. Baez. Her name was Joan Baez. I used to love to hear her sing. So, um, but now I think that last name is associated with baseball now. Uh, oh, you at work? Okay. Okay, no problem. You're good. You're good. But yeah, wasn't Harvey Baez, uh, who used to be with the Cubs, and I think now he's with the Mets. I think it is. And the Cubs did a spring training, a spring cleaning in the summer, uh, cleaning their house and everything. So, but didn't bother me because I'm a diehard Sox fan. Go White Sox. Yeah. All right. Jennifer said no. Why, you a Cub fan, Jennifer? Okay. Okay, you can still be one of my favorite students uh, with an asterisk next to your name. Uh, yeah, I was around some people today, and they were wearing jerseys, and I had my socks. I didn't have a jersey on. I had a Sox polo shirt and my Sox cap on today. So I didn't want to come to the lecture um, wearing that, but I did come to the lecture with this. One of my one of my church members gave me this. She said, she asked my wife whether I was Sox or Cubs. She says, "No, you didn't. You didn't ask that question. Not of not of Richard Wright." But anyway, um, yeah, I feel you, Jennifer. Sox have been where the Cubs are right now. So, but it's our turn. Okay. Well, again, welcome to week 6, the final week of this class. And next term, I will be teaching um, contemporary issues in criminal justice, J280, for anybody who's wondering what classes to stay away from because I'll be there. Or Introduction to Corrections. I think some of you been in, Jennifer, you were in that Introduction to Corrections class, I think, or was it? Yeah, yeah. I think you were in also Drugs and Crime with me too, weren't you? I know. I remember. I remember students. I don't think anybody else in here has been in any of my other classes. For some reason, I want to say Lynn and Juan have been in one of my classes. Have you? Oh, okay. Um, so get ready. Get ready. Continuation. Um, so, oh, okay. Okay. I didn't think so. I thought the name's kind of, but I will tell you this, and Jennifer can vouch for this. It's a very interesting class, that Introduction to Corrections course. And I'll tell you a unique feature in there that um, in this class, you had how many quizzes? Two, right? You had one week 3, which was equal to your midterm. And then you have one coming up this week, which is week 6, which involves materials from weeks 4, 5, and 6 only. And so remember what I told you, but I'll go over that at the end again, how to best prepare for it, and remind you again that what you're going to see in the practice quizzes, you'll see them in variations. And there was even, I know one question that a student told me, said it was the question already in the practice quiz. But the key thing is if you know the material, and I do my best to try to prepare you for that. If you know one thing, and I'll tell you this before we get started with week 6, is that if you have done the assignment and follow the rubric and module, listen to me good, and the discussion post, those two things, followed by the reading and using the PowerPoints, you can do well on the timed quiz, and your grades will be reflecting that as well. So let's go ahead and share my screen here. Okay, here we go. All right, I'm going to the student preview just for a minute, and then we're going to go to the regular view. So messages, you see all the messages from me to you guys. PowerPoints for excuse me, week 6, which I sent you on Sunday, and then the other stuff from the previous weeks as well. You don't see your individual emails that you sent me here because it's a student view. All right. So now let's take a look at, and by the way, remember, the worst way to reach me is through this. The best way is to text me or call me. And if you don't remember the phone number, I'll show you where to find it, but you should easily be able to remember it. It's in the it's in 2 places. It's in the syllabus, and it's also in that introduction that I do. You'll see my phone number there as well. All right. So let's look at the grade book. Week 6, you will notice something. Every day assignment due is Saturday, right? No. See if you're paying attention. It's really Friday, because if you submit your assignments on Saturday, no deal. The course ends at 11:59 p.m. Central Standard Time on the 17th. So notice point 1, discussion, murder or self-defense. That is the reply post that is due on the 17th. The initial post is due when? Anybody know when the initial post is due? Yep, tonight. That's right. That would be September the 14th. So your initial post is due, and then your reply post is due by Saturday. Of course, though, as I tell several students, you don't have to wait until the due date. You just don't want to try to submit it after, especially this. I can't give an extension beyond the 17th, except with one way, and I'm not going to tell you what that is. We kind of discussed it during week one a little bit, but you would have to talk to your advisor about it, or better yet, look at your syllabus and you'll see the answer to that question. But I'm the key to that, the same way as I have been with extending late assignments. If you guys have paid attention very carefully to your grades, um, all the way from week to week 4, I've been very liberal with uh, late dates, unless you were real late with your assignments without letting me know why. So your discussion post, murder or self-defense, and then you don't really have any more, quote, research written assignments. So you got plenty of time to prepare for this quiz, because you don't your last written assignment was submitted this past Sunday. So um, you 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 can focus on this. All right. Then so you study for the quiz, and you already know how that works. And then your live classroom phrase. So let's take a look at the discussion. Self-defense. Murder or self-defense. You're going to look at this scenario, and in your initial post, you're going to answer the question, will the clerk be able to justify self-defense? Explain why or why not. Identify a self-defense statute in your state or another state and explain why the elements of self-defense have or have not been met in the scenario. And then in the reply post, contrast yours with another student. Defend your position regarding both questions that you addressed in the initial post. So again, the initial post tonight, reply post Saturday. I said it again. Somebody's going to say, you said Saturday twice. Seeing if you're paying attention. It's Friday. It's Friday. Friday, 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 Friday. Wasn't a mistake. It was just making sure that you're focused in on doing what you're doing. And then you have this guide to help you as well. So that's the discussion post. We're going to talk about the topic of self-defense. One of the favorite tools of us defense lawyers. I won my very first case with a self-defense in an unusual case. If I have a chance, I'll mention that a little bit. Okay, and then of course I'm not going to show you the quiz, and then your live classroom phrase. All right. So now let's go back to the regular view. Okay, good. I'm out of the student preview. So let's take a look at the calendar. For the last time, guys, for this term, we are here, and it shows you your initial post, your live lecture. And again, if you click on this, it'll take you to the initial post saying that it was due today. Then it'll also tell you your lecture took place. Not at 8:45, that's what time it is now. That's Central Standard Time. So 8:30 to roughly 9:30, and then there's the link. If I clicked on that, it would create a problem for us, and I'm not going to do that because we're already here. Then notice this. This is it. The 17th. The 17th, not the 18th, not the 19th, or the 20th. Okay. So that is the calendar, which, by the way, I've shown you almost every week, and also you had it at the beginning of the course because I set it up before you guys started your classes. let's take a look at the announcement, which kind of echoes everything that I just said. Defenses to criminal liability. Again, this is a lecture that's for defense attorneys, um, and also law enforcement people and people who are working to understand how it works. And so you're going to read chapter 10 of the text. I gave you the corresponding PowerPoints to help you prepare for your quiz as well. So we're going to look at the issues of mental disorder, also known as the insanity defense, involuntary intoxication, mistake of fact, mistake of law, and then we're going to close with self-defense and then deal with the key terms for practice and mistake of fact and the practice quiz so you can be ready. Again, the live lecture is tonight, 8:30 p.m. Central Standard. Don't have to tell you that, but you're here. Discussion post murder or self-defense. We went over that. Notice the highlighted due date for assignments is, you see Friday highlighted in there as well for those who missed it earlier. And then finally, that last statement is reminding you that the term ends Friday the 17th at 11:59 p.m. And so take time to do the student evaluation you received in your email pertaining to the course, how you felt about the course, and those kind of things. And then my patented line to finish strong, reminding you, finish strong. I believe you, wanted you to continue to be strong. In other words, start strong, stay strong. And then adversity is a springboard to success. Those of you who've been in my classes know Jennifer knows it all too well, has heard it before and seen it before. And I remind my students that I'm here and can be very empathetic towards you guys for stuff that I know. And sometimes students concerned because I don't respond to emails as fast, but I don't particularly care for the important stuff that you need to know from me, or if you need something or want to let me know something, email is the worst way, because the fact that sometimes this system, the way it's set up, I had two students to send me emails that I got like 4 days after they sent it. I don't know why, but it just showed up all of a sudden. So text me. Um, okay, so that's the announcement. The last thing before I get to the actual lecture is again to remind you where you can find how to reach me on the phone. If you go to your syllabus, it'll jump right out at you as soon as I can move this anyway. There's the phone number. Then my patented line. Okay, make sure that you do that. So you're done with this because you don't have any of this stuff to deal with anymore because your last paper was last week. So let's do it. Let's do well on that quiz. I know you will. You're all prepared. All right. So now let's jump right into the module. Defenses to criminal liability. We talked about discussion. We talked about the quiz, the live classroom recording, which, you can click on that and that shows you something that you don't need to know right now. Those of you who are here, because you're here, but it tells you the link. This is for those who aren't here. Then of course, this will disappear after we finish this, and we'll go back to the, excuse me, we'll go and put the recorded lecture. Then your key phrase that comes in here and goes there. So, all right. So now let's take a look at one of the four topics that we will discuss tonight, just to give you a little an additional stuff to support your reading. So we're going to talk about what we call affirmative defenses. What is an affirmative defense? Affirmative defense, very simply, is a defense where you, first of all, number one, you admit that you committed an offense. That's number one. Very important. You admit that you committed the offense. But secondly, you're saying, I did it legally, or it's justified. And that's what self-defense is. That's what the mental disorder is, and a couple others. Involuntary alcohol and drugs. You'll see that when we get to that. But or excuse defenses. That's another way of calling it. So either of these things are what self-defense, mental disorder, that we're going to be talking about right now. All right. So let's look at the mental disorder defense. Let me make a statement up front to each of you guys. In the many years that I practiced law as a lawyer and represented people, and I had some pretty heinous crimes that took place, I was never able to be successful with the insanity defense being used. I did go through the process of doing so, filing motions to have my client examined, as you will see, by a doctor. Excuse me, but the doctor came back and said that, yes, it was bizarre, but the person was not, did not fit into any of these um, types of things that should happen. We're going to discuss three ways that insanity is determined. So it has to do with the person not having mental capacity to have committed the crime at the time. Okay. So it says, in other words, defendants for whom this defense is raised don't dispute they committed the crime. As I said, they argue they don't have the requisite knowledge or intent, kind of like a baby situation there. Okay. So it's not very easy to prove. And one of the cases, excuse me, I'll just tell you up front, was what was this kid's name? He's out now. Hinckley, John Hinckley. Anybody familiar with that name, Hinckley? Other than Hinckley and Schmidt, the water. Yeah. So you know that Hinckley was the person who attempted to kill President Ronald Reagan. And he actually shot at Reagan and hit the press secretary, Brady, and thus came, he was crippled permanently, and then he died some years later. And thus came what we call the Brady Law for dealing with background checks. Yep, there we go. And so we then have a few other people. Most recently, a person who served a lot of time, and they believe that he might have been, but he wasn't found. That is Sirhan Sirhan. Sirhan Sirhan is the guy who just got out after many years. He shot and killed the late Robert Kennedy in a hotel kitchen as he was campaigning to be president of the United States. And but it wasn't that, but that was one of the issues that was argued. But back to Hinckley. Hinckley just recently was released after many, many years. Now, you're going to discover just up front that when a person is deemed to be insane, fits within the definition of one of these tests, they don't go home. They don't let them go. They don't put them on house arrest. Those individuals are then committed to a hospital until they're deemed sane. So there was a lady that wasn't one of my clients, and I've talked about her before in other classes. Her name was Amanda Wallace. You can even Google it. Amanda Wallace. Amanda Wallace was a woman who had her child taken away by the Department of Children and Family Services. And somehow or another, she was able to get the child back. Well, shortly after she got the child back, who was an infant, young kid, uh, within a short period of time, she stabbed him multiple times and he died. And she was determined to be insane at the time of the offense because she thought that she was stabbing an animal or a pig and didn't have the capacity. Her mental state was gone. So she had no business with the kids. DCFS really kind of fumbled the ball on that one. Those of you who are in Illinois kind of know a lot about the DCFS and their horrible, horrible um, determination about kids. I used to be a foster parent and was an advocate for families and kids, and I know, anyway, their record is not so good. So anyway, I saw Amanda when I went to visit one of my clients at 26th in California, which is the Layton Courthouse, where I went to the jail section there, and she was in a corner balled up and she was rocking. And you could see something was wrong with this person. She wasn't feigning it or nothing like that. And so she was found not guilty by reason of insanity. Um, that's my, yeah, I think that's what happened. And but she's passed away now since that time. So if you are found not guilty by reason of insanity, as I said, you go to a mental hospital, but there is not a finding of guilty. Okay. And then you stay there until a doctor says you're competent and safe to be released. Trust me, that sometimes never happens, or it takes many, many years. Now, most states have insanity defense, except my last check, Idaho, Kansas, Montana, and Utah don't have it. But here's the interesting part. While they don't have that, but they do allow for guilty but mentally ill verdicts. So the effect is the same thing. It's just what the verdict is called. Remember, in most jurisdictions where you are found not guilty by reason of insanity, you can be found guilty but mentally ill in these 4 states here. All right. Okay. So now let's talk about the first one of the 3. Now, they're going to sound all similar, but you need to listen carefully, pay close attention, because of the fact that this is going to be on the test. I already know. That's all I'm going to tell you. All right. So let's talk about the Norton rule. That's how it's pronounced, Norton. It's not M. Norton. It's Norton. The M is silent. And it started out with, is where most of our laws came from, and that's England, except one state, which is Louisiana. They do the Napoleonic Code, which is French based. So you are deemed not guilty by reason of insanity if at the time you commit the crime, you have what we call a diseased mind that prevented the defendant from recognizing or knowing right from wrong. Okay. This is also called the right-wrong test. All right. So the person had such a status of their mind that they didn't know right from wrong, kind of like babies, that kind of thing. For example, as it gives some good ones here, at the time of the murder, defendant thought that he was stabbing someone with a knife. he thought the knife was a straw. Or at the time of the murder, the defendant knew they were stabbing someone with a knife, but for some reason, which is the mental condition, they thought they were doing nothing wrong at all. All right. So the state of Florida uses Norton, and it says, which insanity defense, which presumes everybody is sane. Well, anyway, I'm not going to comment on that. And insanity is an affirmative defense. Remember what I told you. You have to say, yeah, I did it, but I was insane at the time. All right. So once again, the defendant had a mental infirmity, disease, or defect that was so bad they didn't know what they were doing, or that they didn't appreciate the consequences. That's it. That's the Norton rule. You should have that. This is called the right wrong, not as WRIGHT either. It's the right wrong. All right. The Durham is easy to remember because it only applies in one state, and that's good old New Hampshire. And it's known as the product of mental illness test. So it was established under the case of Durham versus U.S. back in 1954. That was long before I became a lawyer. I was 4 years old. But they didn't like the right wrong test. But look at what they came up with. This is the funny part about it. They didn't like the right wrong test or the Norton rule. So they said that in order for a person to be found, it stretches the Norton. It says here, let's put it like this. The Durham test is more liberal than Norton and stretches the intellectual question of, here's the sole question in New Hampshire. Did the defendant know the difference between right and wrong? That is expressed in Norton. That's it. They don't take the other part of Norton. Okay. So it's can be confusing. I will say this to you. You won't be able to confuse the two in the way that the questions are asked of you. You should be able to get it clear. So for all practical purposes, in most jurisdictions that have the insanity defense, you're going to have either the Norton rule or the next one that I'm going to talk about, which is the substantial capacity test. Now, pay close attention. This is really easy for you to recognize. So jurisdictions wanted to have it standardized as much as possible and try to, as they say, stamp out Norton altogether. Obviously, Durham didn't do that. And so they said, but rather than to look at knowing right and wrong, rather as a result of a mental disease or defect, however, lacked substantial capacity to appreciate the wrongfulness of their act or conform to requirements of law. So, excuse me, if you look at that term, substantial capacity, I remember we were in law school raising the question, well, okay, hold it. Does this mean, isn't substantial capacity a relative term? Well, yeah, but you know what you need to be aware of is that statutes make it clear by clarifying it, such as Wisconsin has substantial capacity. Now listen to the language that I'm going to read for you here. A person is not responsible for the conduct at the time if the result of mental disease or defect lacks substantial capacity either to appreciate the wrongfulness of their conduct. So going back to what my original statement, everybody's presumed sane, and depending upon the state, the burden of proof to be successful is a mere preponderance of the evidence or clear and convincing evidence, not beyond a reasonable doubt. So you can still have some doubt there. But if you come down on the side that you believe that that person actually was um, guilty of not guilty by reason of insanity, then in that case, they could not have been substantial in terms of their actions. They didn't have the capacity. Does that kind of make sense? Everybody got that? Okay, because it's very easy. All right. But most of these people, as I said, will spend the rest of their lives in mental facilities. All right. So now let's move on to involuntary intoxication. Involuntary means what it says. It is also as an affirmative defense if that person was intoxicated involuntarily. They did not themselves decide to take a drink or get high and then claim to be intoxicated. And the burden of proving this is preponderance of the evidence in most jurisdictions. As you see in the Michigan statute, it is an affirmative defense to a specific intent. It has to be a crime that is specific intent. So you have to have the specific intent. And by the preponderance of evidence that he or she voluntarily consumed, legally obtained, and properly used medicine or other substance and did not know reasonably or should not have known that they become intoxicated or impaired. Now, how can that happen? Taking a double dose. There have been times when, you know, I've had to say, "Oh, did I take my medication this day?" Because if I took a second dose, then it could um, it could put me in a position where I've done exactly this. So if it was done not on purpose but accidentally, now you forgot. But here's what I'm going to tell you. Pay close attention to your medication when you look at it. There is almost on all medication a statement that says, "Do not take this and drive." That is a disclaimer that the people like myself, called lawyers, um, put in to protect the company, okay, the drug manufacturer. So that puts on notice the individual. If the person does so, they do it at their own peril. However, it is harder to use that statement if you're the prosecution because of the fact that a sharp lawyer who's defending someone would say, well, that's a civil issue. That's a civil issue. Okay, so that they're relieving themselves of liability or protecting themselves. It is not a criminal issue. And the judge would say, pretty good, Mr. Wright. That means you know your law. And that's exactly how it will work. So again, remember, it's not done on purpose. The fact that a person charged with a crime, I'm reading the Kansas now, was in an intoxicated condition at the time the alleged crime was committed is a defense only if such condition was involuntarily or by mistake and rendered the person substantially incapable of knowing or understanding the right or wrongfulness of their crime. All right. Now, another way that can happen is the famous spiked drink, where someone prepared and dropped something in your drink, and then you did something. Like the example, and this happened to my brother-in-law who's passed away now many years later, but when he was much younger, and um, taking something, this example in here brings it home. A college student, Jim, partying all night, has to take a test the next day and doesn't want to fall asleep in class. So one of his classmates gives him a white pill and says it's a caffeine pill, and that it had helped him stay alert. But he didn't tell the truth. The pill what it actually was a prescription methamphetamine hydrochloride pill, and he had an adverse effect which caused him to go berserk, panic, and rage. So in his defense, um, he breaks the windows, destroys merchandise, so he can prove that he was involuntarily intoxicated and may not be found guilty of vandalism. But that's that's an example there. But the common example is when somebody gives a person a Mickey. When I say Mickey, do you guys know what I'm talking about? You know what a Mickey is? Okay, a Mickey is actually um, an alcohol or drink. It could be non-alcoholic, where someone puts something in there or spiked your drink to make you. You know what? You've heard of date rape? You heard the term date rape before? Okay, Lynn, that applies there where a person was seduced. Kind of like the allegations of Cosby and Epstein, and was the other guy, the the movie producer guy. What's his name? Weinstein, Harvey Weinstein. Those kinds of things, where women were given those to um, mess them up so they can be taken advantage of. And that's what that is. So in that case, that person can allege that they were driving or doing something or they committed a crime because they weren't in control and was involuntary. Got it now, Lynn? Got it? Oh, okay, great. So let's move on. We got two more to go. Mistake of fact and of law. This is the easy. This is so easy. This is very easy. Very easy. Let's talk about mistake of fact. You're saying ignorance of the law is no excuse. That is a true statement. So you're not absolved because you engaged in conduct and didn't know it was illegal. No, that's not what this is. But the Missouri law, like other mistake statutes, the defense can be claimed if the actions is related to an element of law in question. So let's consider this. Lisa is making a large purchase of home goods, including a lawnmower, and she puts um, the lawnmower thing at the bottom of the cart, and while paying for the items, she's distracted by her cell phone and forgets to bring to the attention of the clerk that the item is under the bottom. Like you go on Walmart or a store and I've had a case of water or something like that that's under the bottom. So she pays and leaves the store. When she leaves the store, the loss prevention officer informs her she didn't pay for the lawnmower, calls the police, and requests that she be charged with theft. Well, Lisa would say, "Oh, I'm sorry. I didn't realize that. It was my bad or mistake." This is not ignorance of the law, number one. This is she didn't intend to steal it, but she intended to pay for it, but so she didn't have the requisite intent. And so the clerk neglected to scan the lawnmower. Something like that has happened to all of us. I remember one time I left my wallet in the car, and my wife was at Walmart, and we had a bunch of juices on in the cart, and we took them out, and I rode I used one of those electrical carts that I ride around. And so I went out to the car. When I got out to the car, I realized inside the basket was one of those containers. Well, it hadn't been rung up. So if I was stopped by the security, I would have the same issue, but I wasn't. So I came back and I said, "Oh, I forgot to give you this. You need to ring this up." And so the young lady says, okay, and she scanned it through and I paid for it. So that's what we call a mistake in effect. Oh, okay. Another mistake of fact can happen, for example, where you pick up um, a bag or something and you discover that, later, oh, this is not mine. And you try to bring it back and they say, aha, you stole it. No, 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 no. You did it in error. You're going to see this in a fact scenario coming up in a few minutes about a person with an animal. Um, and so you'll see mistake of fact illustrated there too, how it would be on a test. So now let's talk about mistake of law. It's also very easy. Um, if a person violated the law, but believed their actions were indeed legal. Now, it's not the same as I said of ignorance of the law. But a mistake of the law can apply in several cases where a person relied upon a law that was later found to be unconstitutional, where a person acted in good faith consistent with a judicial opinion but didn't apply it properly, a person acted upon the advice given by a person or agency, pay attention, responsible with administering the law, such as a police officer, or a person committed an act contrary to law that has yet to be published. Okay, and those are some of the things. Now, you should note that within the definition, an example of mistake of law defense, there is no reference to the idea of ignorance, but permits the defense um, if mistakes are made. So here's one that brings it right home with Paul here, a suspended driver's license he had, and was driving, wanted to drive his ATV to work. So remember, he had a suspended license. So Paul's mother called the local sheriff and asked the sheriff deputy if Paul could operate his ATV, even though his license was suspended. Paul was advised to operate his ATV as long as he followed other laws. One day while he was on his work, Paul was stopped for speeding on his ATV. So he was violating the law. But he was also cited for operating with a suspended license. Paul was convicted of operating while suspended, and the court didn't permit the jury to consider his mistake of law. That is the opinion that was told him by the sheriff. Paul appealed his conviction, and it was overturned because it was a mistake of law. The appeals court said that the trial court erred and should have allowed that mistake of law evidence to be brought in. So Paul only drove his ATV after or because of bad advice he had been given by a sheriff's deputy charged with enforcing the law. Does that kind of clear it up? Get you there? Person of authority. There could be an argument by some people that their lawyer told them that something was illegal, and you can have the same potential argument depending on what judge you might have. But this is a stronger case where you got a police officer telling you. All right. The final section is where I started talking about earlier, is self-defense. And it is basically a law that makes your actions justifiable. Now, it points out very clearly at the beginning that self-defense laws don't presume that force used against another is justified, but that the burden of proof by the defendant um, is justified to stop an unlawful interference against them or someone else. So an unlawful interference can include being punched, shoved, kicked, grabbed, strangled, or held against one's will. Now, the key thing is the amount of force that the person who defends himself uses. It must be appropriate to stop the unlawful interference and not go beyond that, period. That's it. That's it. So once the unlawful interference is stopped, the force must also stop and cannot escalate. All right. This makes it clear. The victim, Bob, is walking on the sidewalk with Margaret. Pay attention to this one very carefully. Bob and Margaret are approached by a drunk man who threatens to punch Bob in the face. Bob tries to avoid the conflict and tells the man just keep walking. The man shoves Bob, draws his fist back to him. Bob reacts quicker and punches the man, and he falls to the ground. Now, so far, okay. But Bob was upset because the man tried to assault him. He jumps on top of the man and beat him until he became unconscious. Margaret pulls Bob off the man, and they wait for the police. So the question is, was the force initially used by Bob to stop the intoxicated man from hitting him legal and justified? What do you think? Yes or no? Yes, it was. But what about when Bob got on top of him? Did he go too far? Yes. Yes, he did. Absolutely. And that's the whole point in a nutshell. Our great state, Illinois, has a statute that says a person is justified in the use of force against another when, to the extent they reasonably believe that such conduct is necessary to defend themselves or another. You are justified in the use of force which is intended to likely cause death or great bodily harm only, they should have only highlighted, if you reasonably believe that such force is necessary. Reasonably believe that it's necessary to prevent imminent death or great bodily harm to yourself or to someone else or the commission of a forcible felony. That's it. That's it. Okay. So we already cleared that out. Most states don't require a person to retreat or try to retreat before self-defense. This is known as stand your ground. You should know that stand your ground became the topic of much debate after the Trayvon Martin case, and involving what was the guy's name? George. What was the defendant? I can't think of his name, but you know who I'm talking about, who was a neighborhood watch guy. And so it became a debate. And I personally believe that he went beyond standing his ground because the police told him to stand down and he went after the kid. And then, you know, the rest of what happened. So uh, individuals can't assert stand your ground if they are committing a crime when they are attacked. Also, you cannot claim self-defense in cases where you provoke the attack. Some states will permit, George Zimmerman, thank you. Some states will permit a self-defense claim in instances where the person attacked could have been using force. So ask yourself, is your state a stand your ground or duty to retreat state? I hate duty to retreat because a lot of things can happen in that process. All right. Let's talk about the battered women syndrome. The battered women syndrome is a law that now actually should be called battered spouse syndrome because it could be male or female. And it's been used in cases to justify the murder when a person has been the subject of domestic violence for many, many occasions, and then enough is enough, and they take steps and will result in them killing that individual. So um, uh, the environment is such that violence includes force. Now let's look at this example here, and then I'm going to tell you one that I know of for real. Diane has been physically abused and battered many times by Jim, her husband, during 10 years of marriage. Each time he's drunk, and when she is battered, the worst, has been knocked out and choked unconscious. One night, Jim comes home drunk. and they start to argue over his drinking problem. Jim escalates toward Diane. She's fearful that she'll be battered again, shoots Jim. Diane is likely to argue self-defense in conjunction with battered women syndrome. Now, I know of a case of a person who was like Diane. Uh, the only thing, though, that she did was she let him go to sleep. Then she got a gun and shot him while he was sleeping. And battered women syndrome didn't work there. However, I saw the transcript. I read the transcripts of my friend, and I believe that a good defense attorney before a jury, individuals who could relate to understanding that, would probably even given her a pass even in those situations, because to argue that she wasn't in charge even at that, because the battered syndrome that she had found herself in had taken away her ability to think right, even if she did do something. But the prosecution argued successfully that no, she was still in a state where she plotted, she knew. The argument could be made that, well, she woke him up, she wouldn't be able to do it, and he would come violently at her. She wouldn't have that opportunity. Yeah, that's that's the argument. You got it. You got it in a nutshell. And yeah, how else do you plan an escape? And that is my argument in a nutshell. But I didn't have a chance to do that. I believe I could have done it. And the jury, not a judge probably would have found her guilty. But the jury, if given a strong argument in support of what you said, Jennifer, um, is that she had been, her mind was so like, ugh! You know what I'm saying? You got what you feel kind of like what I'm doing here. Uh, the, the multiple beatings, yep, flight or fight. And the multiple beatings, though, created that environment of her. And how was she to know if when he woke up, he wouldn't do that? So that's the whole point in a nutshell. So woulda, coulda, shoulda, woulda. But anyway, she ended up being found guilty and served time. Very nice young lady. We went to high school together and grammar school together. But that's the battered women syndrome. The castle doctrine means what it says. Your home is your castle. So what it does is it says that if someone attempts to enter your castle uh, you can use deadly force to stop the intrusion. And you have, they don't require the person within the dwelling to retreat or prove that the person unlawfully entered it, but they did so possibly with intent. They don't know whether they were injured. Okay, thank you. I will see you again. So we will continue for about 5 more minutes, and then we're going to take a hard stop here. But the point of the matter is that you can defend yourself in your residence. Okay. Now, the last thing I want to talk about is use of force by police officers. Police officers can use force. And I think that is something that I don't really have to explain very much to you guys, because the George Floyd, Derek Chauvin case with those other officers kind of like busted wide open, is that the force necessary should be to control that individual and not go beyond that. If you do so, you're guilty of excessive force. And like they're talking about restraint in the use of deadly force. I'm not going to talk about that because you already know what I'm talking about. So the point of the matter is you can look at these clips and you can see the issues that are involved there. So Police are held to the standard of reasonable force based upon the circumstances in terms of protecting themselves or others. Let's go to key terms. So we talked about each of these terms. Be aware of what they are, because you're going to see them on the test. All of these, I don't see anything in here that I haven't covered. Okay? Be sure you pay attention to those. Now, let's do this little practice here for a few minutes. Start the activity. Okay. I kind of set you up for this one earlier in the lecture. Jane has a white cat named Snowball that wears a pink collar and is let out each day. One day the cat doesn't return. A few days later, while out looking for her cat, she finds Snowball and brings her home. However, later that day, she realizes that the pink collar has a tag that says Princess on it. She contacts the police, but she fears that she'll be arrested for the theft. So, what is this? Just what I remember. I kind of like led you into this. All right. Yep. So you put that in there. Oh, I'm sorry. Mistake of fact. I hit the wrong one. But yeah, it's mistake of fact. Okay. You're right. Eric waves down a police officer and asks, here's another one that I set you up for. My landlord locked me out of my apartment. Can I break in to get my stuff? The officer says, go ahead. It's your place. Eric breaks in, and the landlord says that he was arrested for burglary. What is this? Mistake of law. Remember the same with that ATV situation. An authority told him he could do it there. One last one. Okay, I gotta select one. Okay. Officer White is working a theft case and believes he has the right to enter without a warrant the suspect's apartment to retrieve stolen items. Just to be sure, he speaks with the on-call judge and explains the case. The judge advises Officer White to enter the apartment, retrieve the items, which he does. It's later determined that the officer violated the defendant's Fourth Amendment rights. This is a mistake of what? Of law, because he was advised by the judge. Absolutely. Okay. So you see. All right. Finally, the infamous practice quiz. You are defending a case where the defendant is accused of killing his friend during a schizophrenic episode and believed he had to kill his friend because he was the devil. You don't believe that Derek knew the difference between right and wrong at that moment. The test that should be applicable is which one? Yeah, because it told you in the answer. Exactly. It sounded like substantial capacity, but it was actually the Norton rule. Yep, applicable is in this case. David is hanging out with friends at a local bar. Somebody places an unknown liquid in David's drink, which caused him to go crazy. Strip his clothes off and throw him through the windows. He's arrested and transported to a local hospital. The next day, David has no recollection. What affirmative defense will David claim in this case? Yep, because that was an example of a Mickey that I was talking about. One last one. What level of proof must be met in order to successfully prove an intoxication defense? Yeah. If you said probable cause, you failed the course. These are standards for arrest and reasonable suspicion. You'll stop and frisk. So it'd be either beyond a reasonable doubt, which you already know, that based on what we talked about in the lecture. I set you up for that. So 51% more certain. So that's it. There are more. Go over those and be able to do that. So, any questions? All right. Looks like none. Um, Key phrase. See if you got it. What do you think I got in mind? It's written right here. What do you think it is? No, no guess? No. How about this one? Self-defense. Yeah. Self-defense. You got it around the time I said it. So yes, it is self-defense. There you go. Well, that's it, guys. I enjoyed again, and nice having you again, Jennifer, in another class. I hope I see you um, further down the road, and wish you the best. I wish all of my students success. Remember, I'm here if you need me, and I'm sure you guys will continue to excel and follow. And hopefully I've imparted some wisdom in you and knowledge about criminal law. You're not criminal lawyers, but you do understand some stuff that you may have not understood at first. And so hopefully I've added to your knowledge, and that it will help you to become as I like to say, educated professional and remain an ethical criminal justice professional. So if you need me, you know how to reach me. I have many students who reach out to me through Facebook, Richard Wright JD, and become my friends, and many years after reach out to me, and I've written letters and helped them become employable, or help them get jobs, and those kind of things. So letters of recommendation, those kind of things. Okay, well, I'm going to say good night. Enjoy your break. What do you know what you're taking next term? Do you know what you're taking next term? Oh, okay. Applied criminal procedures. I don't know who's teaching that one. Um, Patty Laney, or I'm trying to think of who else could teach that. Maybe do you know who the teacher is? Not yet. Okay. You know Patty Laney though, right? Yeah, she was the one that collaborated with me in drugs and crime. That's my buddy. We always would have fun. She was a prosecutor most of the time when I was defense attorney, and we would have fun uh, putting our perspectives together. We could do one of those great debates on the issue, and both of us would be right. So, all right. So again, enjoy the rest of your evening. Continue to take care of yourself, your health, and stay safe. And I'll see you down the road. Good night.